Can I have some information on what you had talked about earlier, the treatment, or I didn't.
Sure.
fully
Let me
grasp what it was.
let you know what I have, everyone. So I have an email from Guadalupe. She's one of the discharge planners. She works in the with a psychological team over at the jail.
It was through the county.
Then you get to speak. Go ahead. Go ahead.
I explained to Ms. Davis that the court determines the term of probation, that it is anywhere from 2 to 10 years. And when I prepared the paperwork for her to sign this morning, she said she's not agreeing to probation. She does not at this stage understand that deferred adjudication is a form of community supervision. And based upon that, she said she wanted a trial.
Oh, okay. All right. Well, that's fine.
That's a question. Is deferred adjudication also probation?
It's under the general terminology of probation.
Okay, then I'm okay. Just waive the fine and then we can do the deferred adjudication.
I'll try again to do the paperwork, Judge.
Yeah, the difference between regular probation is you're found guilty, sentenced, then your sentence is suspended so long as you follow the terms and conditions of probation. In deferred or unadjudicated probation, there is no finding of guilt, but you're on similar conditions of supervision. The length of time is the same. You can be no less than 2, no more than 10 years confined term of probation. It's in the court's exclusive discretion under law, and in both regular and deferred probation in this county, we terminate probations early in a third if you've done well. So, you can do the math. Yeah.
How's that affect my license to practice?
I don't know.
Okay, just making.
There is enough, the record will reflect there is sufficient evidence supporting a finding of guilt. However, no finding will be made so long as the defendant follows the terms and conditions of probation. That rendering does make a difference in some environments, some issues that bothers whoever the licensing authority is, but all of those are all unique and different. I don't know how it applies. You're talking about the practice of law.
Yeah,
I don't know how it will apply, really. But I do believe I know some lawyers who are currently on deferred or unadjudicated probation who are practicing law. Okay, so
I'll work on trying to get the paperwork for him. That's not working. 009.
I've been further advised that if I am unable to afford counsel, one will be appointed for me free of charge. Understanding my right to have counsel appointed for me free of charge if I am not financially able to employ counsel, I wish to waive that right and request the court proceed with my case without an attorney being appointed for me. I hereby waive my right to counsel. I understand that I may withdraw a waiver of the right to counsel at any time. I am making this decision freely and voluntarily. If you'd be so kind to sign, thank you. And this is for the record for all purposes. And again, do you waive a formal reading of this indictment? Can we proceed in summary once again?
yes.
In summary, this indictment alleges that on or about September 24th, 2020 in Jefferson County, Texas, you committed the first-degree felony of aggravated assault on a public servant, which carries with it a term, if convicted, of life imprisonment or any term of not more than 99 years or less than 5 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand what you were charged with and the punishment range applicable.
Yes,
An agreement has been reached where you would not be found guilty, but placed on deferred or unadjudicated probation, which can be up to 10 years in length, no fine. There will be terms and conditions of probation, which will be prepared. The court will approve. These are normal and customary for this type of offense. Do you understand?
yes,
If I follow this agreement, you will have no right of appeal of your case. Do you understand?
yes,
How do you plead to this offense charging you with the first degree felony of aggravated assault on a public servant? Guilty, not guilty, or nolo contendere, no contest?
no contest.
Are you pleading no contest voluntarily, knowingly, intelligently? And do you understand the consequences of pleading no contest, which is a plea of no contest, has the same effect as a plea of guilty, except it generally cannot be used in any civil actions brought forth from the facts of this case that you were pleading no contest to?
Yes,
So there's no plea guilty here on this. I think it's been neutralized before, and we took out so that it would work both ways for no contest. And how do you plead no contest to this charge?
yes,
I show you what's marked as State's Exhibit 1. Did you sign that document voluntarily? Did you understand it, discuss it with your attorney? Are the contents all true and correct?
yes,
State's Exhibit 1 tendered into evidence, and without objection, it is admitted. Stand down. Among other things, this states that you are mentally competent to enter your plea, which is freely and voluntarily made. You understand what you are charged with. The indictment's been read to you, or you read it. You are guilty of the crime charged and any lesser included offenses. You are getting it through your plea of no contest. You are giving up your rights of jury trial and the right of the appearance, confrontation, cross-examination. You were totally satisfied with the representation provided by yourself in this case, since you were self-represented, and you swear all of this is true, so help you God.
yes,
State's Exhibit 1 is made a part of the record for all purposes. Because this is no contest, the state has an opportunity to read into the record any additional evidence which supports the defendant's no contest plea, so that there is enough evidence presented for the court to find the defendant guilty and then defer those proceedings under this agreement. And you can, or this is going to have to be later sworn to right here.
Yes,
You can proffer the information.
Just a second.
There has to be an independent presentation. I don't, unless you want to throw in the
According to
probable
the-
cause affidavit.
I'm going to tender the information from the probable cause affidavit provided by Officer Trey Armstrong with Beaumont Police Department.
Okay,
All
a copy of that can be made a part of the record. Is there any objection to it, ma'am?
I'm sorry, the police officer.
Yes.
I thought he was a fire marshal.
Well, whoever the person is who prepared, I'm presuming it was a
The victim
an
was,
officer of some sort, but anyway, here, this is it. Have you seen that? He's gonna put that into evidence from the state's presentation, then you can make any objections or changes to it.
Object to a Object to the wording of the statement denied. Object to swinging of the knife.
Is that it? Is that all?
Yes, sir.
Okay, the rest of it, without objection, except for that portion dealing with, the knife, then, it is made a part of the record as, state's exhibit sticker. Please. Problem is, you're gonna have to add something else, on your own unilaterally, since that makes up an element of the offense, right? What it takes to make a first degree felony is the use of a deadly weapon. He's objecting to that portion of state's exhibit 1. She's pleaded no contest to this. There still has to be an independent presentation when there's not a plea of guilty. It's to support a no contest plea.
my position is that her objections are not lawful. She's given no grounds as to why she's objecting to those matters. This is a probable cause that has been a portion of the court's file. Is nothing more than a recitation of the facts, as well as the admissions that she's already made that are contained within the indictment, as well as State's Exhibit 1, which is the judicial confession.
Admissions.
What essentially what he's saying is really, you don't have to agree this is correct, but it is his proffer from the state's presentation that that's what he his evidence shows is true and correct in this. You can object, but otherwise that it's his presentation. This is what he is alleging he is presenting as an independent presentation that his case would show, and you're objecting only to that portion dealing with a knife. Your objection is noted. It will be overruled. The state's Exhibit 1 is admitted, and your objection to the use or presentation of a knife is going to be shown in the record that you differ on that, but yet you are pleading no contest to the indictment, which includes as an element that a deadly weapon, namely a large knife, was used.
Honorable proper addition, there's a civilian witness by the name of Tasha Coleman who is on standby for the testimony in this trial. Her specific statement, as well as testimony that she would provide in trial, verifies that this individual began to swing a knife at the fire marshal, which is Terrence Simon. I'm quoting directly from her report. The state has that physical evidence in and would present it in trial. Officer Simon is available as well to testify about the knife that she is swung at him. The officers that responded are, and additionally would testify in trial, are Officers Armstrong, Price, Roberts, Gilmore, and Leslie, that all had dealings with her that day, that also affirm those accusations that are subject to this conversation.
Okay.
I object again to Tasha's statement.
Yeah, just fine.
So
You are allowed to introduce other documentation if you want to do that, to support that. That just. Are you objecting, or are you going to just not? Or are you intending, because I know your goal is to get the end accomplished, which is placing you on deferred or unadjudicated probation. But this step we're stumbling on this step. Are you insisting on objecting, or are you just going to stand mute? Once again,
I am.
Otherwise, he'll be entitled to present more evidence into the record. And that may or may not be what
Tendering a statement.
you feel is in your best interest in the end game of what you were trying to complete here. Because each element of the offense that constitutes the offense, there has to be some evidence to support it under a no contest plea.
So the statement that I saw, this wasn't in the record. This was in the record. So I will refer to the additional second page. The one page was the only thing that was in the record.
Yes, ma'am. Go ahead.
So let me look real fast.
Yes, ma'am.
What's the number we're at, Judge?
I'm sorry.
What exhibit number are we at?
I've got Courts Exhibit 1, which is the election to self-represent, and that's been admitted. You've got States Exhibit 1 is the only thing I have. Then we also have here, well, there's two States Exhibits. One, this is going to be number 2. States Exhibit 1 was part of the plea papers. We're going to call this
Let's make
States
that
Exhibit
3.
You want this 3?
Yes, sir, because States Exhibit 1 is the judicial admission. Court's admonishment as to,
It's Courts 1.
so we've got States 1 should be the admonishment within the plea.
We're States 2.
Let's make that States 3, which you have in your hand.
Okay.
This will make this
3
States 2.
is what's already been introduced and admitted as States 1. We have corrected that to States 3 because States 1 is part of the plea papers that are already in evidence. So where's your States Exhibit 2?
States 2 is being
Gender,
reviewed by the defendant. It is a statement from Natasha Coleman.
Natasha Coleman identifies it as a spatula, not a knife. It's a spatula that she mentions. I still, object to the swinging. I object. She says spatula again. Let's see. And I charged at her. I object to that. At no point did she say on the 911 call that I charged her. She said there were other people in the facility that possibly could have gotten charged with anything. I was walking around. That's when we saw right outside. When we saw a fire marshal truck pull up, that's when I asked him if I can get the police here sooner. We went back to his truck to make a call, and they came back and said, "When I approached her, she began to swing the spatula at the fire. She wasn't there. There was no female standing there with me when I spoke to him." So I object to her statement. Page 2. I object to the fact I do agree to the spatula that she mentions in her statement.
That still doesn't make the element of the offense, which is a deadly weapon was used, which she's pleading no contest to. The States Exhibit 2 is also introduced into evidence, but it's objected to by the defense in her version of the facts.
And the state's position is those are not legal objections. Those are her saying that something happened differently in an attempt to try to testify to the court.
I understand.
I
Your
Yes, Your Honor.
objection. They're admitted.
Thank you.
Under the method of this plea, she's pleaded no contest and understands what that means under the law, and that the elements have been supported by not only her plea, but states 2 and 3, which is the real estate's and which are 2 and 3, which are reports that the state contends support the indictment in this case. Anything else by anybody? If not, I'm going to make the following findings: that the defendant has pleaded no contest and understands and it's pleaded voluntarily, knowingly, intelligently, understands what that means, that it is not admitting guilt, but with independent evidence under state's exhibit 1, 2, and 3 to support the no contest plea. That is enough to find the defendant guilty beyond a reasonable doubt. It is not usable, though, under any civil matters which may be brought about pursuant to the underlying facts and allegations of this case, but it does support the elements of the crime to find the defendant guilty beyond a reasonable doubt. However, I'm going to follow this plea agreement and defer any finding of guilt and place the defendant on deferred or unadjudicated probation. Again, here are the deferred or adjudication orders, which are normal and customary for this type of offense. And this is for a term of 10 years.
Oh, okay. Okay, I've never met you, so I'm standing with you. Nice to meet you. Okay, here we go. Sorry, I didn't know who he was.
No, I'm glad you all were able to meet each other. So does she have a warrant? Thank you.
Your Honor, may I have,
Please don't say anything to the court, just let them check, please.
I mean,
Yes.
I just wanted to make a statement.
And this is not the time or the place. Please don't make any statements to the court.
Okay,
It's Monday. Has Nahia watched Ken Porsche?
That's why
Let me just tell you, if he ends up watching that, I think we're gonna have thunderstorms.
it's gonna happen. If he will be willing to drop charges, considering.
All right, so August 31st, what happened on that day?
Place 1 month prior to my text messaging him, which was only a text message of reconciliation.
And so for today.
All right, so Ms. Gutierrez,
She didn't look, the warrant, but it was recalled because the foundation, it said foundation stuff.
okay, so Ms. Gutierrez, your conversation with your attorneys, who your attorney is, or y'all want to have a meeting, that needs to take place not in front of the bench. Do you understand?
So how was I able to talk to him though? 'Cause he was up
You
here.
guys need to do that on your own time.
So he
Yes,
didn't
Your Honor.
notify us. I do apologize. I didn't know he was present, my attorney.
All right, you all want to step back and talk to her?
Yes, Your Honor. Let's put a hold.
All right, Jeremy Ray Garcia.
Versus Layla Ray Ann Tanton. Could I have parties announced for the record for the state
Hank Wilkins for the state.
defense?
Charles May for the defense, Your Honor, ready.
Are you Ms. Tanton? And counsel, have you received all of the discovery? Did you review it with your client?
Yes, Your Honor, I have.
Court will find that the state is in compliance with discovery. Ms. Tanton, I'm showing you what's entitled application for deferred adjudication or community supervision. Did you review that with your attorney? Did you understand it and did you sign it?
Yes, ma'am.
Next, I'm showing you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
Your Honor, we're waiving count one and proceeding on count two, Judge.
Any objection?
No objections, Your Honor.
Ms. Tanton, I'm showing you what's entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand in count two, you're charged with the offense of possession of a controlled substance, penalty group 1, 4 grams to 200 grams. That's a second degree felony. The range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, ma'am.
Did you intend to give up those rights and enter into a plea in this case?
Yes.
Did you understand that the court would grant your application for deferred adjudication? If for any reason your deferred adjudication were revoked, the court could find you guilty, sentence you up to 20 years in prison and up to a $10,000 fine?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor. Yes.
Do you believe she has a rational as well as a factual understanding of the charges against her?
Yes, Your Honor.
Do you believe she's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Ms. Tanton, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No,
Anyone promised you anything other than the plea?
no, ma'am.
Satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes,
Court will find that the defendant has knowingly and voluntarily waived her right to jury trial. Showing you the plea bargain page, did you review that with your attorney? Did you understand it?
yes, ma'am.
According to the plea, state is proceeding on count 2 and they're recommending deferred adjudication. Did you understand that to be the plea?
Yes, ma'am.
Defense?
Yes, Your Honor.
State?
Yes, Your Honor.
Showing you the waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
None, Your Honor.
Next, I'm showing you outside the plea bargaining agreement. The state is recommending that your deferred adjudication be for a term of 5 years. There'll be a TAP evaluation, 120 hours of community service restitution, and an evaluation for felony drug court. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to count 2, how do you plead? Guilty, not guilty, or no contest?
Contest.
State, any evidence?
Your Honor, I offer State's Exhibit 1 and the attachments.
Any objections?
No objections, Your Honor.
All right, state, you may continue to confer. Ms. Tanton, I'm showing you what's entitled Waiver and Consent to Stipulation of Testimony and Stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent? Did you understand that today the state would be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. Court will defer finding you guilty as you've applied for deferred adjudication. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Your Honor, we would just ask that the court proceed with the deferred adjudication. My client is deeply remorseful of what she's done, her actions, Judge, and she would ask this court to follow the agreement that has been in place, Your Honor.
All right, how old are you?
I'm 21.
21?
Yes, ma'am.
Do you have any children?
I have a daughter.
How old?
She'll be 4 November 6th.
And where is she?
She's with my mother in Houston.
Is Child Protective Services involved?
No, ma'am, I have full custody, no CPS cases.
Well, did you give up your rights to your mom?
No, I did temporary guardianship. My daughter has.
I'm sorry, could you?
I said, I gave temporary guardianship. My daughter.
All right,
has-
everyone, please whisper.
My
yes.
daughter has juvenile rheumatoid arthritis, so she gets the best medical care over in Houston. My mom works at the hospital, so.
How far did you go in school?
I went all the way into my junior year, and I did cosmetology school and completed all my hours.
Okay. So when's the last time you had employment?
I worked at Golden Chick. I would say it was March. It was March through April.
And what does your mom do at the hospital?
My mom is head coordinator of San Jack Methodist.
And do you have any other siblings?
Yes, I have a brother and a sister. A
All
younger
right.
brother,
And
too.
what does your brother and sister do?
My brother is a barber. He's in barber school, and my sister is going to be graduating high school in about a year and a half.
All right. And who is this Michael Martin to you?
It's my ex-fiance.
What is that ex-fiance since this happened? Before you were arrested, how often were you doing meth?
I wasn't. One.
Okay, I find that hard to believe. I don't think you're just doing marijuana. I think there's more to it. And let me just tell you why I say that. I say that because I've read the police report. So I think it's more than marijuana. And I'm going to tell you something right now. One, I'm inclined to go along with this deferred adjudication. If you tell me you don't have a meth problem, you know what I'm going to do? I'm going to send you out into the world. I'm going to make a notation that you said you didn't have a meth problem. And you know what's going to end up happening? If you go out into that world and you're going to be drug tested, and when you're drug tested, you test positive for meth, I'm not going to want to hear that, oh, I have a meth problem, because I'm asking you right now to be honest with me so I can set conditions so that perhaps you can get your life together. Perhaps you can be in your daughter's life, because right now, the only thing you're doing is hanging around with a fiance who has parole violations. Did you know he had a criminal past?
I did, ma'am.
And you still thought, let me get with this guy who has a criminal past. I have a 4-year-old daughter who has medical needs, but eventually, because this guy is my fiance, this is the guy who I think would be great to be in her life. A person who's only doing marijuana doesn't believe that. Someone who's doing meth and other things believes that, because you're just trying to get your next fix. And if Michael Martin has parole and has been to, which if he's on parole, that means that he's been to prison. And if you think somebody who's been to prison with the charges that they have in this police report that he's on parole for, if you think that's a good person to be in your daughter's life, that tells me you're doing more than marijuana. So this is the last time I'm going to ask you, and we can pretend like this is the first time I'm asking you, if that will help you be honest with the court. How often are you using meth?
I stopped using meth. I did that for my daughter because I was going to lose my family.
So when did you start using meth?
Started whenever I got with my fiance.
So why are you before the court pretending like you don't do meth and you've never done meth?
I'm not pretending like I haven't done it. I just
Now you're playing semantics with me, and I don't appreciate that, because I clearly asked you how often you were using meth. I know you're not using meth today because you're in court, and the deputies would not have brought you over with the items to do meth in the box. I asked you how often were you using meth, And you said, I don't use meth. I haven't used meth. That's what you said. And you're playing games with me, and I don't appreciate that. I already knew you used meth because that's in the police report. Nobody is driving around with this much meth in the car unless you're using it or unless you're selling it. And obviously there was an issue with you because I don't know why people are driving around San Antonio smoking a blunt in the car and you think the police are not going to pull you over. All right. Is there anything else?
Nothing. Thank you.
This is what the court is going to do. The court is going to sentence you to 6 years deferred adjudication. We're going to do a TAP evaluation in custody. Follow all recommendations of TAP. If they recommend inpatient treatment, she's going to inpatient treatment. Is felony drug court full?
Your Honor, they are classified evaluations. They will be accepting clients, however, they don't have funding yet, so the clients will be limited.
All right, we'll do a referral to felony drug court. If felony drug court accepts her, she can go there. There's going to be 120 hours of community service restitution. I'm going to want her in intensive parenting classes. Once she completes that, the community service hours will be deemed satisfied. There's to be no contact with Michael Martin. There's to be no unsupervised contact with minors, and that includes her own child. There's to be regular reporting by Zoom or in person. Regular UAs. No, I'm sorry, not regular UAs. We're going to do the UA hotline. When you're released, where are you going to be staying? Who are you going to be staying with? Do you have a place to stay?
I have my own house here.
All right. There's going to be field visits one time per month until further notice. Proof of employment within 45 days of release. There's to be no employment as a home health care provider or with minors. And she either needs to get her GED or complete some type of trade so you can get employment and get employment where you can take care of yourself and take care of your daughter. You understand that?
Yes, ma'am.
So she needs some sort of trade school or either GED. And what I can tell you, because you have this charge, anything, any occupation that requires a license, you need to let them know about this because for some, they're not going to give you a certificate or anything because you have this felony. Do you understand? So before you waste money, ask them if that's going to be a problem. Probation, is there anything else she needs? All right. Is there anything else you need from the court in order to be successful on this deferred adjudication?
No, ma'am.
Okay. I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it and did you sign it?
Yes.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes.
All right, State, with regards to this case, there were weapons. One weapon I think is stolen. So is there any destruction of the weapon?
I believe those were the co-defendant. The co-defendant was charged with that, judge, but I can confirm.
All right, thank you. So if those are your weapons, they're going to be destroyed. Do you understand?
Yes, ma'am.
All right, we can go off the record. What is this tattoo on your neck about?
It's dollar sign.
Why do you have a dollar sign on your neck?
I do my own tattoos. Just practice.
But no, why would you put a dollar sign? It has to mean something.
Everybody likes money.
All right, and Vashawn, I forgot on her, we're going to need a MIC evaluation and also also a gang evaluation. What is up with the weapon on your tattooed on your arm?
Did it myself.
And the snake?
I didn't do this one.
All right, what is that about?
My cousin passed away in a car accident that we were both in, and her last name was Rose, so I guess Rose.
All right, and what is the other name underneath your arm?
I'm on my daughter.
Okay. All right, yes.
Judge, that she did have a UCW handgun from the same incident date in County Court 9. But she got a JSAT on that, but I can email those prosecutors to.
Destroy the weapon.
Yes.
All right. Now, let me just tell you, your 4-year-old daughter, she can't go out into the world and make her own choices, right? That's why she's living with your mom. She doesn't have employment. She can't take care of herself. And usually children don't make great decisions, especially at that age, because they want what they want. If you give them candy, guess what? They want candy all the time, right? So your 4-year-old is depending on you to make good decisions, your mom to make good decisions, and you're not. I don't know what you were thinking that you would think it would be okay to bring a fiance in your daughter's life who's been to prison, obviously is not rehabilitated because you all are driving around smoking blunts in a car and he has a parole warrant. You need to either make a decision that you're going to be a good influence and a good parent to your 4-year-old, or either 100% get out of her life. Do you understand? Yes.
Governor, I just want to confirm if she resides here in Bear County or.
Oh, she's going to be here in Bear County. She will not be in Houston. Okay. All right. Thank you. All right, Henry Knight. Why do I keep getting this sticker that you're refusing an interview? Did you refuse? No, come up here. We're not playing games. Come forward. Miss Ferguson, are you saying he refused the interview?
Oh, no.
All right, it's an old sticker. I was just going to say, all right, because I knew Miss Garza had been appointed to represent you. See, communication is key. They put this sticker on here. Defendant refused interview. I'm like,
See, that could have turned ugly real quick.
it could have, but I always communicate, so I want to know what's going on. We don't let things turn ugly in this court.
Yes, ma'am.
All right, so are you all ready to proceed on the motion?
Yes, Your Honor.
Okay. Mr. Knight was scared for a minute. He's like, what? That's not me. All right. Court is calling 2022 CR 8435, State of Texas versus Henry Knight Jr. Can I have parties announced for the record for the state?
Jason Garahan, Your Honor.
Defense?
Counsel for defense.
And are you Mr. Knight?
Yes, ma'am.
All right, Mr. Knight, I'm showing you what's entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Are you the same Henry Knight Jr. who was placed on deferred adjudication in 2022 CR 8435 for the offense of aggravated assault with a deadly weapon on February 21st, 2023 for a period of 8 years? Is that you?
Yes, ma'am.
All right, state.
Yes, Your Honor. Violated condition number 6, on or about the 4th day of May, 2023 in Bear County, Texas, the defendant Henry Knight Jr. departed Bear County without the written permission of the court and or the supervision officer in violation of condition number 6.
How do you plead to that? True or not true?
True.
Your Honor, we'll waive the remaining violated.
Any objection?
No objections.
Did you understand by pleading true to violation of condition number 6, the court could find it true, grant the motion, find you guilty, sentence you up to 20 years in prison and up to $10,000 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 6?
Yes, ma'am.
Court will find violation of condition number 6 true. Is there a proposed agreement?
There is, Your Honor.
What are you requesting?
Adjudicate guilt, revoke the defendant off his probation and sentence him to 2 years in the Texas Department of Corrections.
All right, counsel, is that the agreement?
It is, Your Honor.
Mr. Knight, are you asking the court to follow that agreement?
Yes, ma'am.
Are you waiving your right to appeal?
Yes, ma'am.
All right, just give me one moment. All right, probation. On this case with Mr. Knight, was there any restitution to Marvin Trimble? Okay. All right, thank you. Then the court will follow your agreement, find you guilty, sentence you to 2 years in the prison, give you credit for any time served. There's an affirmative finding of a deadly weapon. There's to be no contact with Marvin Trimble, Trimble. Is there anything else from either side with regards to sentencing?
No, Your Honor.
Mr. Knight, I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, we can go off the record. How old are you, Mr. Knight?
Just turned 30.
All right, so you just turned 30 years old. You're going to prison for 2 years. Think about your life and think about where you want to be. If you continue on this path, you're going to wake up and you're going to find that you spent a majority of your life either in somebody's jail or at somebody's prison. I don't think anybody wakes up when they're in elementary school and say, you know, when I grow up, I want to spend the rest of my life in prison, or I want to go to prison, or I want to go to somebody's jail. So you need to find that little boy who wanted to do something with his life, and you need to start doing that. Do you understand?
Yes, ma'am.
All right, good luck to you. Thank you, Ms. Garza.
Thank you.